Dr. Ciccone, what, if any, other conclusions did you come to after interviewing and reviewing all of the materials?
Objection, Your Honor. This would require an improper opinion which the witness has not been proffered as an expert.
Correct.
Your Honor, no conclusion has been elicited to show that it would require any expert knowledge yet. This could be simply based on rational perceptions, and if I may make an offer of proof, it is indeed based on rational perceptions. It requires no expert knowledge.
Also, then please approach the bench to be. You can make your proffer at the bench.
Proper.
Outside of the presence of the judge.
Your Honor, the expert is about to offer an opinion that is not based on expert testimony. The conclusion is that he was lying based on contradictory statements that he heard. This requires no knowledge, training, or experience. It requires simply basic knowledge of logic, that two statements contradicting one another cannot be true.
Your Honor, if the witness, I would object to an opinion that the witness is lying in any way, shape, or form. There's no tests, no profession, no expert knowledge that would allow him to testify in court today that the witness is actually lying in the course of the test. If counsel wishes to elicit any opinion from him, I would ask that more foundation be laid, and so that we can determine whether the witness has the appropriate qualifications.
Is that the only other opinion we're going to find?
Yes, Your Honor. Again, I maintain that it requires no qualifications. Dr. Ciccone, in your evaluation, did there come a time where John Draft mentioned a blackout?
Objection.
Yes, Your Honor. Dr. Ciccone, when speaking to the defendant, did he ever explain to you what happened to him on the day of May 13th, 2011?
Yes, during our interview, I asked him what was the last thing he remembered before the blackout, and he told me that he remembers going to the defendant's house to confront him. Then I asked him what was the last thing he remembers after the blackout, and he says...
Objection, Your Honor. This is not responsive to the question asked by counsel.
Your Honor, he is indeed responding to the question I asked about what the defendant told him about the events of May 13th, 2011. There were subsequent events afterward that were also mentioned as part of this by the defendant. He would be allowed to do so.
I think his answer has gone far afield from the question you asked. Motion is granted.
So, you mentioned that he talked about something after that.
Yes.
What was that?
He said he remembers a week later, but he also mentioned a murder or a shooting that occurred 3 days after he was incarcerated.
What shooting was that?
It was a shooting of
relevance. 403.
What part of 403?
Your Honor, at this point in time, the witness has already testified that he remembered a shooting that occurred during the period of time that he was supposedly in a blackout. To elicit more testimony as to the nature of the shooting, who was involved in the shooting, would unfairly prejudice the jury because they may have already had prior knowledge of those particulars.
And has it been elicited from this witness?
It is about to be elicited from this witness, Your Honor.
Okay, but it hadn't been elicited from this witness before.
It has not been the exact participants in that prior shooting have not been elicited from this witness, Your Honor. But they're irrelevant to the issue of whether John Draft is guilty for murder here today, Your Honor. The fact that a shooting occurs and that John Draft possibly recalls some of those events is sufficient to bring in the onus or the players in that particular murder would undoubtedly prejudice the small town jury who has undoubtedly heard about this murder.
Your Honor, may I be heard?
Yes,
First of all, I fail to see any prejudicial effect that may result from the names involved in an event in which the defendant claims he remembers during a claimed blackout of his. Any mention of the names involved in an entirely separate shooting would in no way affect the jury's impermissible inferences that the
And
jury
that
may
would be
make.
your opinion, correct, counsel?
It is simply unrelated to today's trial.
But that's your opinion, isn't it, counsel?
Well, it's my argument, Your Honor, that it's unrelated to today's trial and in no way lead to any improper inferences on the part of the jury.
Defense motion granted.
Thank you.
May continue.
You mentioned you reviewed charts in coming to your conclusions regarding the defendant.
Yes, that's correct.
The record reflects I'm approaching opposing counsel, who has been pre-marked for identification purposes only. As defense exhibit 6. Again, Your Honor, I'm not sure since we seem to have page issues. We'll be able to find it under tab exhibit 6. Permission to approach and tender the documents to the witness.
Granted.
Dr. Chacona, can you identify what I've just handed you?
Yes, that's the Minnesota Multifaceted Personality Inventory, or the MMPI.
Is it pertaining to any particular person?
Yes, it's pertaining to John Hugh Dark.
And did you use this as part of your conclusion?
Yes,
Is that a fair and accurate copy of the printout that you used in coming to your conclusions?
yes,
This time, State offers Exhibit 6 into evidence.
State, defense has no objection to the commission on exhibit 6.
Admitted.
Permission to approach and retrieve the document and to publish to the jury.
Granted.
Permission to use an enlarged demonstrative. Your Honor,
Yes.
permission to approach, to use an enlarged demonstrative.
Yes, sir.
Your Honor, defense would request the opportunity to review the enlargement to ensure that it's an accurate representation of previously exhibit 6. Thank you, sir.
Not hearing any objections, you may use the.
Dr. Chacona, you mentioned that you came to the conclusion that the defendant did not and does not have a mental disease or defect.
correct.
You mentioned that you did so using this chart.
Yes.
Can you explain how this chart helped you come to that conclusion?
Objection, Your Honor. There's been a lack of foundation for the use of the MMPI results at this point in time. We have not had any mention of how this affects how this has affected his evaluation or how it's used in psychiatric evaluations at all. And at this point in time, I haven't had the opportunity to cross-examine the witness on what he has the appropriate qualifications to administer an opinion on the MMPI results.
Having had the witness qualified in general psychiatry, I believe your arguments go to the
So again, how are you able to use this chart in coming to your conclusion?
Well, there are 3 scales in the MMPI designed to determine the authenticity of responses. These scales are L, F, and K. These scales will tell you if the subject is dissembling.
Can you explain to the jury what dissembling is?
A line trying to...
Objection, Your Honor. Mischaracterization, improper opinion.
Your Honor, this is in no way a mischaracterization. It's in fact a term used in psychiatry that is being explained for the helpfulness in order to help the jury. And in no way is a mischaracterization of the evidence or the materials that Dr. Chacona relied on.
Your Honor, as offered in my earlier argument, there is no test or no expertise that will qualify a witness to stand in the stand and state that someone was lying. The witness has already testified that the L scale is measuring someone's deception, but in no way, shape, or form would indicate how someone is lying. Polygraphs are not even admissible in court, Your Honor, and those are considered lie detector tests. To allow the validity of some tests to determine whether Mr. Draft was being truthful or not would be substantially prejudicial and would have very little purpose.
Your Honor, this is what he relied on in coming to his conclusion that the defendant lacked a mental disease or defect. The fact that he's lying is part of that conclusion. It's not an ultimate conclusion that he's come to necessarily. And in addition, if I may make an offer of proof, this is a report prepared by the defense's expert itself. To now deny the permissibility of the state's expert to explore the results would be improper and shut the door on something that, well, I have no faith and belief the defense will use later on.
Your Honor, it's not my contention that the counsel can't examine what the L scale measures. In is simply that he cannot state on the stand through the witness or himself that that scale measures someone lying. There is no scientifically acceptable test or reliable test that will allow someone to come to a courtroom and discern that someone is lying. The issue of credibility and veracity is totally for the witness, for the jury, and not for the witness to talk about it.
Your Honor, in addition, the testimony has already been elicited that the defendant was dissembling. All right, this is apparently already means, according to Dr.